Okay, going live with Chapter 10, the decision whether to prosecute. 1, same title as the chapter. The charging decision made by the prosecutor, except in minor cases, involves the determination of whether a person should be formally accused of a crime and thus subjected to trial if he does not first plead guilty. Although the charging decision is not inevitably so complex, it often involves these determinations. 1, whether there is sufficient evidence to support a prosecution. 2, well, in parentheses it says, which, as a practical matter, the prosecutor will determine by assessing whether the likelihood of conviction is sufficiently strong to justify the use of resources to that end. And then 2, if so, whether there are nonetheless reasons for not subjecting the defendant to the criminal process. And 3, if so, whether non-prosecution should be conditioned upon the defense participation in pretrial diversion program, such as probation, but without an antecedent conviction. The American prosecutor has traditionally exercised considerable discretion in deciding whether or not to prosecute, that is, in determining whether prosecution is called for in a given case as a matter of enforcement policy. The explanations for this phenomenon most often given are A, because of legislative overcriminalization, B, because of limitations in available enforcement resources, and C, because of a need to individualize justice beyond the possible under existing crime definitions and sentencing options. This discretion is largely uncontrolled, especially when the prosecutor elects in a particular case not to proceed with prosecution. There is seldom available any mechanism by which any dissatisfied person may challenge that decision. When the prosecutor instead decides in favor of prosecution, the defendant is obviously motivated to challenge this exercise of discretion and at least sometimes may have a potential legal basis for doing so, such as that his selection for prosecution is a denial of equal protection of the laws or constitutes an impermissible chilling of some constitutional right. But as United States v. Armstrong teaches, it is very difficult for a defendant to prevail in such a challenge. Okay. So United States v. Armstrong is the first case in this section. It's a 1996 case. Chief Justice Rehnquist delivered the opinion of the court. In April of 92, respondents were indicted in the United States District Court for the Central District of California on charges of conspiring to possess with intent to distribute more than 50 grams of cocaine-based crack and conspiring to distribute the same in violation of 21 U.S.C. Section 841 and 846 and federal firearms offenses. For 3 months prior to the indictment, agents from the Federal Bureau of Alcohol, Tobacco, and Firearms and the Narcotics Division of the Inglewood, California Police Department had infiltrated a suspected crack distribution ring by using 3 confidential informants. On 3 separate occasions during this period, the informants had bought a total of 124.3 grams of crack from respondents and witnessed respondents carrying firearms during the sales. The agents searched the hotel room in which the sales were transacted, arrested respondents Armstrong and Hampton in the room, and found more crack and a loaded gun. The agents later arrested the respondents as part of the ring. In response to the indictment, respondents filed a motion for discovery or for dismissal of the indictment, alleging that they were selected for federal prosecution because they are Black. In support of their motion, they offered only an affidavit by a paralegal specialist employed by the Office of the Federal Public Defender representing one of the respondents. The only allegation in the affidavit was that in every one of the 24 Section 841 or 846 cases closed by the office during 1991, the defendant was Black. Accompanying the affidavit was a study listing the 24 defendants, their race, whether they were prosecuted for dealing cocaine as well as crack, and the status of each case. So they did a study Nice. The public defender's office, actually. The government opposed the discovery motion, arguing, among other things, that there was no evidence or allegation that the government had acted unfairly or has prosecuted non-black defendants or failed to prosecute them. The district court granted the motion. Really? What motion? The discovery motion? It ordered the government, 1, to provide a list of all cases from the last 3 years in which the government charged both cocaine and firearms offenses. 2, to identify the race of defendants in those cases. 3, to identify what levels of law enforcement were involved in the investigations of those cases. And 4, to explain its criteria for deciding to prosecute those defendants for federal cocaine offenses. The government moved for reconsideration of the trial court's discovery order. With this motion, it submitted affidavits and other evidence to explain why it had chosen to prosecute respondents and why respondents' study did not support the inference that the government was singling out blacks for cocaine prosecution. The federal and local agents participating in the case alleged in affidavits that race played no role in their investigation. An assistant United States attorney explained in an affidavit that the decision to prosecute met the general criteria for prosecution because there was over 100 grams of cocaine base involved, over twice the threshold necessary for a 10-year mandatory minimum sentence. There were multiple sales involving multiple defendants, thereby indicating a fairly substantial crack cocaine ring, and ... There were multiple federal firearms violations intertwined with the narcotics trafficking. The overall evidence in this case was extremely strong. Okay, so I'm going to say is neutral facts. Race neutral facts. Or justification. The overall evidence in the case was extremely strong, including audio and video tapes of defendants, and several of the defendants had criminal histories, including narcotics and firearms violations. The government also submitted sections of a published 1989 Drug Enforcement Administration report, which concluded that large-scale interstate trafficking networks controlled by Jamaicans, Haitians, and black street gangs dominate the manufacture and distribution of crack. So that's just the dish. That's the racial distribution. In response, one of respondents' attorneys submitted an affidavit alleging that an intake coordinator at the drug treatment center had told her that there are an equal number of Caucasian users and dealers to minority users and dealers. Respondents also submitted an affidavit. These are affidavits. From a criminal defense attorney alleging that in his experience, many non-blacks are prosecuted in state court for crack offenses, and a newspaper article reporting that federal crack criminals. So you got drug treatment center affidavit. You got a defense attorney's affidavit, right? Or criminal defense attorney affidavit. And what else? A newspaper article supporting that federal crack criminals are being punished for far more severely than if they had been caught with powder cocaine, and almost every single one of them is black. The district court denied the motion for reconsideration. When the government indicated it would not comply with the court's discovery order, the court dismissed the case. A divided 3-judge panel of the Court of Appeals for the Ninth Circuit reversed, holding that because the proof requirements for the selective prosecution claim, defendants must provide a colorable basis for believing that others similarly situated have not been prosecuted to obtain discovery. Yeah, which they should have said in the first place. That's the appeal court. To obtain discovery. The Court of Appeals voted to rehear the case in bank, and the in-bank panel affirmed the district court's order of dismissal. Holding that the defendant is not required to demonstrate that the government has failed to prosecute others who are similarly situated. We granted certiorari to determine the appropriate standard of discovery for the selective prosecution claim. So the TC granted this motion for discovery into selective prosecution claim. And later dismissed. Dismissed when state didn't produce. The appeal court put the burden on the defendant, and then the Supreme Court is probably reversed burden. I could be messing this up. And then SCOTUS is now giving cert. Okay. So that's the procedural context. Neither the district court nor the Court of Appeals mentioned Federal Rule of Criminal Procedure 16, which by its terms governs discovery in criminal cases. Both parties now discuss the rule in their briefs, and respondents contend that it supports the result reached by the Court of Appeals. Rule 16 provides in pertinent part, upon request of the defendant, the government shall permit the defendant to inspect and copy or photograph books, papers, documents, photographs, tangible objects, buildings or places, or copies or portions thereof, which are within the possession, custody, and control of the government, and which are material to the preparation of the defendant's defense, or are intended for use by the government as evidence in chief at the trial, or were obtained from or belong to the defendant. That's the statute. Criminal procedure. Respondents argue that documents within the possession of the government that discuss the government's prosecution strategy for cocaine cases are material to respondents' selective prosecution claim. Respondents argue that the rule applies because any claim that results in non-conviction, if successful, is a defense for the rule's purposes, and a successful selective prosecution claim has that effect. We reject this argument because we conclude that in the context of Rule 16, the defendant's defense means the defendant's response to the government's case in chief. While it might be argued that as a general matter, the concept of a defense includes any claim that is a sword challenging the prosecution's conduct of the case, the term may encompass only the narrower class of shield claims which refute the government's arguments that the defendant committed the crime charged. Rule 16A1C tends to support the shield-only reading. If defense means an argument in response to the prosecution's case in chief, there is perceptible symmetry between documents material to the preparation of the defendant's case and in the very next phrase, documents intended for use by the government as evidence in chief at the trial. If this symmetry were not persuasive enough, paragraph A2 of Rule 16 establishes beyond peradventure that defense in Section A1C can refer only to defenses in response to the government's case in chief. Rule 16A2, as relevant here, exempts from defense inspection reports, memoranda, or other internal government documents made by the attorney for the government or other government agents in connection with the investigation or prosecution of the case. Under Rule 16A1C, a defendant may examine documents material to his defense, but under Rule 16A2, he may not examine government work product in connection with his case. If a selective prosecution claim is a defense, Rule 16A1C gives the defendant the right to examine government work product in every prosecution except his own, because respondent's construction of defense creates an anomaly of the defendant being able to examine all government work product except the most pertinent. We find their construction implausible. We hold that 16A1C authorizes defendants to examine government documents, materials of the preparation of their defense against the government's case in chief, but not to the preparation of selective prosecution claims. A selective prosecution claim is not a defense on the merits to the criminal charge itself, but an independent assertion that the prosecutor has brought the charge for reasons forbidden by the Constitution. Our cases delineating the necessary elements to prove a claim of selective prosecution have taken great pains to explain that the standard is a demanding one. These cases afford a background presumption that the showing necessary to obtain discovery should itself be a significant barrier to the litigation of insubstantial claims. A selective prosecution claim asks the court to exercise judicial power over a special provision of the executive. The Attorney General in the United States attorneys retain broad discretion to enforce the nation's criminal laws. They have this latitude because they are designated by statute as the president's delegates to help him discharge his constitutional responsibility to take care that the laws be faithfully executed, citing the Article 2 of the U.S. Constitution, Section 3, that these are executive officers. It's not a defense to the merits of the criminal charge itself. I mean, this is just crazy to me. I think before that we were talking about what goes into discovery. And we were talking about this as a shield and a sword before that. And then we started talking about some crazy symmetry analysis or analogy that I don't seem to understand. So, where are we? Quoting again the U.S. Constitution, the presumption of the presumption of regularity supports their prosecutorial decisions, and in the absence of clear evidence to the contrary, courts presume that they have properly discharged their official duties. In the ordinary case, so long as the prosecutor has probable cause to believe that the accused committed an offense defined by statute, a decision whether or not to prosecute and what charge to file or bring before a grand jury generally rests entirely in his discretion. Of course, a prosecutor's discretion is subject to constitutional constraints. One of these constraints imposed by the equal protection component of the Due Process Clause of the Fifth Amendment is that the decision whether to prosecute may be based on an unjustifiable standard such as race, religion, or other arbitrary classification. Euler versus Bowles, 1962. A defendant may demonstrate that the administration of a criminal law is directed so exclusively against a particular class of persons with a mind so unequal and oppressive that the system of prosecution amounts to a practical denial of equal protection of the law, from Yickwo versus Hopkins in 1886. So this is like kind of a case law, I want to say standard doctrine. That's what we have to reach for this to be viable. This case is argument. In order to dispel the presumption that a prosecutor has not violated equal protection, the criminal defendant must present clear evidence to the contrary. The criminal defendant does this. We explain in Waite T. versus United States in 1985 why courts are properly hesitant to examine a decision whether to prosecute. Judicial deference to the decisions of these executive officers rests in part on the assessment of a relative competence of prosecutors and courts. Such factors as the strength of the case, the prosecution's general deterrence value, and the government's enforcement priorities, and the case's relationship to to the government's overall enforcement plan are not readily susceptible to the kind of analysis the courts are competent to undertake. It also stems from a concern not to necessarily impair the performance of a core executive constitutional function. Examining the basis of a prosecution delays the criminal proceeding, threatens to chill law enforcement by subjecting the prosecutor's motives and decision-making to outside inquiry, and may undermine prosecutorial effectiveness by revealing the government's enforcement policy. The requirement for a selective prosecution claim draw on ordinary equal protection standards. The claimant must demonstrate lost my spot. That the federal prosecutorial policy had discriminatory effects and that it was motivated by a discriminatory purpose. To establish a discriminatory effect in a race case, the claimant must show that similarly situated individuals of a different race are not prosecuted. The requirement has been, so this is really required of defendant. In a different race were not prosecuted. This requirement has been established in our cases from Onsen v. Widman, 1905. Onsen, a subject of China, petitioned the California State Court for writ of habeas corpus seeking discharge from imprisonment under a San Francisco County ordinance prohibiting persons from setting up gambling table rooms barricaded to stop police from entering. He alleged in his habeas petition that the ordinance is enforced solely and exclusively against persons of the Chinese race and not otherwise. We rejected this contention that this averment made out of a claim under the Equal Protection Clause because it did not allege that the conditions and practices to which the ordinance was directed did not exist exclusively among the Chinese, or that there were other offenders against the ordinance than the Chinese as to whom it was enforced. The similarly situated requirement does not make a selective prosecution claim impossible to prove. 20 years before Onsen, we invalidated an ordinance as adopted by San Francisco that prohibited the operation of laundries in wooden buildings. Yik Wu Supra, the plaintiff in error, successfully demonstrated that the ordinance was applied against Chinese nationals, but not other laundry shop operators. The authorities had denied the applications of 200 Chinese subjects for permits to operate shops in wooden buildings, but granted the applications of 80 individuals who are not Chinese subjects to operate laundries in wooden buildings under similar conditions. We explain in Onsen why the similar situated requirement is necessary. No latitude of intention should be indulged in a case like this. There should be certainty to every intent. Plaintiff in error seeks to set aside a criminal law of the state, not on the grounds of that is unconstitutional on its face, not that it is discriminatory in tendency and ultimate actual operation in the ordinance was that it passed on in the Yik Wu case, but that it was made so by the manner of its administration. This is a matter of proof, and no fact should be admitted to make it out completely when the power of a federal court is invoked to interfere with the course of criminal justice of the state. Although Onsen involved federal review of a state conviction, we think a similar rule applies where a power of a federal court is invoked to challenge an exercise of one of the core power. Oh my God. Stupid. What was I saying? Core power of the executive branch of the federal government, the power to prosecute. Having reviewed the requirements to prove a selective prosecution claim, we turn to the showing necessary to obtain discovery in support of such a claim. If discovery is ordered, the government must assemble from its own file documents which might corroborate or refute the defendant's claim. Discovery thus imposes many of the costs present when the government must respond to a prima facie case of selective prosecution. It will divert prosecutors' resources and may disclose the government's prosecutorial strategy. The justifications for a rigorous standard for the government's prosecutorial strategy. The justifications for a rigorous standard for the elements of a selective prosecution claim thus require a correspondingly rigorous standard for discovery and aid of such a claim. The parties and the courts of appeals which have considered the requisite showing to establish entitlement to discovery describe this showing with a variety of phrases like colorable basis, substantial threshold showing, substantial and concrete basis, or reasonable likelihood. However, the many labels for this showing conceal the degree of consensus about the evidence necessary to meet it. The courts of appeals require some evidence tending to show the existence of the essential elements of the defense, discriminatory effect, and discriminatory intent. In this case, we consider what evidence constitutes some evidence tending to show existence of the discriminatory effect element. The Court of Appeals held that a defendant may establish colorable basis for discriminatory effect without evidence that the government has failed to prosecute others who are similarly situated to the defendant. We think it was mistaken in this view. The vast majority of the courts of appeals require the defendant to produce some evidence that similarly situated defendants of other races could have been prosecuted but were not, and this requirement is consistent with our equal protection case law. And fair lending, LOL. The Court of Appeals reached its decision in part because it started with the presumption that people of all races commit all types of crimes, not with the premise that any type of crime is the exclusive province of any particular racial or ethnic group. It cited no authority for this proposition, which seems contradicted by most recent statistics in the United States Sentencing Commission. Those statistics show that more than 90% of the persons sentenced in 1994 for crack cocaine trafficking were black, 93.4% of convicted LSD dealers were white, and 91% of those convictions for pornography and prostitution were white. Presumptions at war with presumably reliable statistics have no proper place in the analysis of this issue. The Court of Appeals also expressed concern about the evidentiary obstacles defendants face, but all sister circuits that have confronted the issue have required that defendants produce some evidence of differential treatment of similarly situated members of other races or protected classes. In the present case, if the claim of selective prosecution were well-founded, it should not have been an insuperable task to prove the persons of other races were being treated differently than respondents. For instance, respondents could have investigated whether similarly situated persons of other races were prosecuted in the state of California, were known to federal law enforcement officers, but were not prosecuted in federal court. We think the required threshold of credible showing of different treatment of similarly situated persons adequately balances the government's interest in vigorous prosecution of the defendant's interest in avoiding selective prosecution. In the case before us, respondent's study did not constitute some evidence tending to show the existence of the essential elements of a selective prosecution claim. The study failed to identify individuals who are not Black, could have been prosecuted for the offenses for which respondents were charged, but were not so prosecuted. This omission was not remedied by respondents' evidence in opposition to the government's motion for reconsideration. The newspaper article, which discussed the discriminatory effect of the federal drug sentencing laws, was not relevant to an allegation of discrimination in decisions to prosecute. Respondents' affidavits, which recounted one attorney's conversation with a drug treatment center employee and the experience of another attorney defending drug prosecution in state court, recount hearsay and reported personal conclusions based on anecdotal evidence. The judgment of the Court of Appeals is therefore reversed, and the case is remanded for proceedings consistent with this opinion is so ordered. Justice Stevens dissenting. The court correctly concludes that in this case, the facts presented to the district court in support of respondents' claims that they had been singled out for prosecution because of their race were not sufficient to prove that defense. That's the end of the page and the end of a sentence. So before I turn the page, I'm going to go into some footnotes. Page prior, they're talking about Batson versus Kentucky. Cut against any absolute requirement that there be a showing of failure to prosecute similarly situated individuals, but the court responded that Batson was different. During jury selection, the entire res gestae take place in front of the trial judge because the judge has before him the entire veneer. He is well situated to detect whether a challenge to the seating of one juror is part of a pattern of singling out members of a single race for peremptory challenges. He is in a position to discern whether a challenge to a black juror has evidentiary significance. The significance may differ if the veneer consists mostly of blacks or of whites. Similarly, if the defendant makes out a prima facie case, the prosecutor is called upon to justify only decisions made in the very case then before the court. The trial judge need not review prosecutorial misconduct in relation to other veneers in other cases. We reserve the question whether a defendant must satisfy the similarly situated requirement in a case involving direct admissions by prosecutors of discriminatory purpose. So that's a challenge, but it's on a different matter. It's not on the matter of selective prosecution claims. It's on some problems with the criminal veneer of voir dire. So Souder concurred with this opinion. So the majority opinion is over. Kind of jump out, but Justice Souder concurring joined the court's decision of Rule 16 only to the extent is application to the issue in the case. Ginsburg concurred, emphasizing that the court was not called upon to decide here whether the Rule 16A, which is the Federal Rule of Criminal Procedure, applies in any other context, for example, to affirmative defenses related to the merits. Breyer concurred in part and concurred in the judgment, though concluding that neither the alleged symmetry in the structure of Rule 16A1C nor the work product exception of 16A2 supports the majority's limitation of discovery under Rule 16A1C to documents related to the government's case in chief. Concluded that the defendant's discovery request failed to satisfy the rule's requirement that the discovery be material to the preparation of the defendant's defense. I'm going to proceed with Stevens dissenting, because I've got 2.5 pages of simply that before we get to the next part of this chapter. And moreover, I agree with the court that their showing was not strong enough to give them a right to discovery either under Rule 16 or under the district court's inherent power to order discovery in appropriate circumstances, like Chief Judge Wallace of the Court of Appeals. However, I am persuaded that the district judge did not abuse her discretion when she concluded that the factual showing was sufficiently disturbing to require some response from the United States Attorney's Office. Perhaps the discovery order was broader than necessary, but I cannot agree with the court's apparent conclusion that no inquiry was permissible. The district judge's order should be evaluated in light of 3 circumstances that underscore the need for judicial vigilance over certain types of drug prosecutions. First, the Anti-Drug Abuse Act of 1986 and subsequent legislation established a regime of extremely high penalties for the possession and distribution of so-called crack cocaine. Those provisions treat 1 gram of crack as the equivalent of 100 grams of powder cocaine. The distribution of 50 grams of crack is thus punishable by the same mandatory minimum sentence of 10 years in prison that applies to the distribution of 5,000 grams of powder cocaine. The sentencing guidelines extend this ratio to penalty levels above the mandatory minimums for any given quantity of crack. The guideline range is the same as if the offense had involved 100 times that amount of powder cocaine. These penalties result in sentences for crack offenders that average 3 to 8 times longer than sentences for comparable powder offenders. Second, the disparity between the treatment of crack cocaine and powder cocaine is matched by the disparity between the severity of the punishment imposed by the federal law and that imposed by state law for the same conduct. For a variety of reasons, often including the absence of mandatory minimums, the existence of parole, and lower baseline penalties, terms of imprisonment for drug offenses tend to be substantially lower in state systems than in the federal system. The difference is especially marked in the case of crack offenses. The majority of states draw no distinction between the types of cocaine and their penalty schemes. Of those that do, none has established as stark a differential as the federal government. For example, if Respondent Hampton is found guilty, his federal sentence might be as long as a mandatory life term. Had he been tried in state court, his sentence could have been as short as 12 years, less work time credits of half that amount. Finally, it is undisputed that the brunt of the elevated federal penalties falls heavily on blacks. While 65% of the persons who have used crack are white, in 1993 they represent only 4% of the federal offenders convicted of trafficking in crack. 4%. 88% of such defendants were black during the first 18 months of full guideline implementation. The sentencing disparity between black and white defendants grew from pre-guideline levels. Blacks on average received sentences over 40% longer than whites. Those a major threat to the integrity of the federal sentencing reform, whose main purpose was the elimination of disparity, especially racial, in sentencing. The Sentencing Commission acknowledges that the heightened crack penalties are a primary cause of the growing disparity between sentencing for black and white federal defendants. The extraordinary severity of those penalties and the troubling racial patterns of enforcement give rise to special concern about the fairness of charging practices for crack offenses. Evidence tending to prove that black defendants charged with distribution of crack in the Central District of California are prosecuted in federal court, whereas members of other races charged with similar offenses are prosecuted in state court. Warrants close scrutiny by the federal judges in that district. In my view, the district judge, who has sat on both the federal and state benches of Los Angeles, acted well within her discretion to call for the development of facts that would demonstrate what standards, if any, govern the choice of forum where similarly situated offenders are prosecuted. Respondents submitted a study showing that all cases involving crack offenses that were closed in the federal public defender's office in 1991, 24 out of 24 involved black defendants. To supplement this evidence, they submitted affidavits from two of the attorneys in the defense team. The first reported a statement from an intake coordinator at the local drug treatment center that in his experience, the number of crack users and dealers were Caucasian as belonged to minorities. The second was from David R. Reed, counsel for Respondent Armstrong. Reed was both an active court-appointed attorney in the Central District of California and one of the directors of the leading association of criminal defense lawyers who practiced before the Los Angeles County Courts. Reed stated that he did not recall ever handling a crack cocaine case involving non-black defendants in federal court, nor had he ever heard of one. He further stated that there are many crack cocaine other than blacks. The minority discounts the probative value of the affidavits, claiming that they recounted hearsay and reported personal conclusions based on anecdotal evidence. But the Reed affidavit plainly contained more than merely hearsay. Reed offered information based on his own extensive experience in both federal and state courts. Given the breadth of his background, he was well qualified to compare the practices of federal and state prosecutors. In any event, the government never objected to the admission of either affidavit on hearsay or any other grounds. It was certainly within the district court's discretion to credit the affidavits of two members of the bar of that court, at least one of whom had presumably acquired a reputation by his frequent appearances there, and both of whose statements were made on pains of perjury. The criticism that the affidavits were based on anecdotal evidence is also unpersuasive. I thought it was agreed that defendants did not need to prepare sophisticated statistical studies in order to receive mere discovery in cases like this one. Certainly, evidence based on a drug counselor's personal observations or on an attorney's practice in two sets of courts, state and federal, can tend to show the existence of a selective prosecution. Even if respondents failed to carry their burden of showing that there were individuals who were not Black but could have been prosecuted in federal court for the same offenses, it does not follow that the district court abuses discretion in ordering discovery. There can be no doubt that such individuals exist, and indeed the government has never denied. Why the district court was unable to take judicial notice of this obvious fact and demand information from the government files to support or refute respondents' evidence. The presumption that some whites are prosecuted in state court is not contradicted by the statistics the majority cites, which show only that high percentages of Blacks are convicted in certain federal crimes. The relevant comparison, rather, would be that with the percentages of Blacks and whites who commit those crimes, but as discussed above, in the case of crack, far greater numbers of whites are believed guilty of using the substance. The district court, therefore, was entitled to find the evidence before her significant and to require some explanation from the government. In sum, I agree with the Sentencing Commission that while the exercise of discretion by prosecutors and investigators has an impact on sentences in almost all cases to some extent because of the 100-to-1 quantity ratio and federal mandatory minimum penalties, discretionary decisions often have arbitrary dramatic effects. The severity of the penalty heightens both the danger of arbitrary enforcement and the need for careful scrutiny of any colorable claim of discriminatory enforcement. In this case, the evidence was sufficient to persuade the district judge and order discovery that might help explain the conspicuous racial pattern of cases before her court. I cannot accept the majority's conclusion that the district judge either exceeded her power or abused her discretion when she did so. I therefore respectively dissent. So that's going to be the first section of Chapter 10, selection of the decision whether to prosecute. The next section will be selection